So, hello, welcome everybody. We have a couple of guests here today of AOMB, a patent attorney firm in the Netherlands.
My name is Arie Blokland. I'm a qualified Dutch and European patent attorney.
My name is Teun van Berkel. I'm also a European and a Dutch patent attorney working for AOMB.
I'm Tim Korsten. I joined AOMB roughly 6 months ago. I'm a trainee patent attorney and I joined Teun with having studied at Correct University, being the TUE, and I did my master's in nuclear fusion.
Nice. So where did you study? Did you mention it already?
Chemical engineering Delft.
Chemical engineering in Delft.
Yeah,
It's a very good university.
Of course, very good.
Yeah. So you're patent attorneys, and I'm sure Sue would like to learn a little bit about what is really the role of a patent attorney in the whole system.
The patent attorney is always involved in innovation. The patent attorney tries to protect innovations from a company. That's basically our task. But we also try to attack patents from others. So sometimes we are on this side of the table, sometimes we are on the other side of the table. But basically we try to protect inventions, innovation. That's basically our task.
I think one thing to add is that many people, when we first talk about the job of the profession of a patent attorney, think that we are the ones that actually grant the patents, right? But we are not. So we are the ones that translate technical innovation, technical ideas into legal documents, patent applications, and we file them at the government. So let's say patent offices, and it's the patent office that actually grants the patents. And we try to help our clients to get those patent applications to grant. I think that's the difference what many people don't fully appreciate or understand often.
So you help them to create a patent, and the patent examiner assesses or judges it upon the patentability.
Exactly.
Yeah, but you have to keep in mind that we start with a blank piece of paper and then we talk with the inventor, and then at the end we have the patent application. So patent attorney is always about words. So you need to be very creative with words, because the product as such is on the table, but it's not in words. You have to translate the product or the process or the apparatus into words. Right. And that's our main task.
So you just mentioned inventors, that's what we talk about in patents. So where do the inventors come from that your company work for? Do they all come from companies? What type of companies? Are there other type of inventors that you serve as well?
I think all kinds of inventors. So if we look at our main business, it's basically multinationals. We work for a lot of R&D institutes from multinationals. But there is a whole, I think our biggest business is still the SME business. So small and medium enterprises, basically in the Netherlands, that do a lot of research and development and coming up with new ideas. But also, I think every now and then we also have a sole inventor. So basically somebody who sits at home, watches TV and gets a brilliant idea, and he calls us and says, okay, I would like to have a patent application. I would like to have this idea protected because I want to sell it or I want to license it or whatever. That's more a unique situation. It doesn't occur that often. Usually it's multinationals and SMEs.
But you forget a big number of clients, the universities. Yeah. We also work for universities across Europe, not only for Eindhoven, for Delft, Twente, but also other universities, because they do a lot of research and they would like to get patent protection. So they call us, could you please help us? Mm-hmm. Yeah. But in principle, we don't want to work for sole inventors because they are not able to bring the product to the market. So that's always a mess. And you will get a lot of discussions about invoices, etc. So we try to prevent working for those type of clients.
I see. And so we talk about technical inventions. Huh? We talk about patents, and I guess much of the work you do you cannot talk too much in public about. But can you give a little bit of sense? What are kind of the most exciting inventions or technologies that you worked about, or maybe some of the funniest examples that you come across here?
You have a nice example.
Yeah,
right?
I have a nice example. It's not funny, but everybody knows it. If you go to a soccer stadium and you see the turf lying on the ground, normally in the past it was only grass, but now we have the hybrid grass, which means that you inject an artificial grass into the grass, and the natural grass will grow around the artificial grass. And that's a very nice innovation, because Real Madrid, Manchester City, Barcelona, Eindhoven, Bayern München, they all have the same type of grass lying there. And it's a wonderful invention, which means that you can play soccer all over the year.
It's and you helped to get that patent out of it.
Yeah, it has already been granted. It has been licensed. It's now at the end of the patent life, but it was a huge invention at that time.
Mm-hmm. Yeah. And do you have some examples of some nice stuff you've been working on?
Well, I mainly work with like very technical stuff. So semiconductors, also for telecom companies. So these are more maybe less exciting as some football field, but they are really critical in let's say the field of electronics and yes.
I think we're going to actually we're going to have some episodes on semiconductors and quantum
Okay.
computing in this series as well.
That's also what we do. But I think it also depends on how you look at it. So it's if you look at appealing patent applications or appealing inventions, appealing for the whole market is sometimes a little bit difficult, but especially turf. Everybody knows what the artificial turf is in a stadium. I studied electrical engineering, telecommunication, and for me, telecommunication patents, let's say the technology is really appealing to me. I really like to work with that. So let's say every patent attorney has a master's degree at the university, and I'd like to work in a field that I studied. So I like to work with telecommunication patents. That's what I would love to do. So if you ask me, do I have any appealing patent applications, then it's in the field of 5G, even 4G a couple of years ago. Now we're working on 6G. Those are for me really the interesting ones, but it's a niche market that's maybe interesting to me, but maybe less interesting for other people.
So I think you just said that all of you studied the technical stuff. The technical master, is that a necessity? Is that like everybody work as a patent attorney?
If you would like to become a patent attorney, you need to have the technical basis. And when you don't have the technical basis, you can never become a patent attorney. If you study English, you can never become a patent attorney. Why is that? Because we talked about innovations. Innovations have a technical background, so you need to understand the technician behind the invention, and you can only talk on a certain level when you have the technical background. So it's a real necessity to have that technical background on a university level.
Yeah, to becoming a Dutch patent attorney, you need a master's degree on a technical university as an entry ticket to enter the post-academic studies to becoming a patent attorney. So for the European patent exams, there are exceptions. So sometimes a bachelor degree could be sufficient, but usually, I guess, if you look in our field, everybody has a master's degree.
Yeah, but there is an ongoing discussion in the European area, because in the UK, you don't need a master degree. You can be a patent attorney with a bachelor degree. But the German people say that you need a master, so there is a big tension across Europe. What is the real requirement to become a patent attorney? But there are different requirements in different countries.
Yep.
In our country, it's masters, but in the UK, it's bachelor.
Clear. Yeah. And now we talked about patents and some successful patents, but do you also advise sometimes people against taking a patent on inventions they come in for?
Yeah, definitely. So I think when we meet a new client or a prospect or whatever, and we sit at the table, I guess one of the first things we ask is, why do you want to apply for a patent? I mean, you have to have a goal to obtain a patent. Is that, do you want to exclude others from the market? Do you want to have some sort of licensing model? Do you want the defensive actions that if somebody sues you, you have something to hit back? Or once every while, people want recognition. They just want to have recognition that they are the first that invented something, which are all valid goals for obtaining a patent. But if you don't have any goals, so why should you apply for a patent, right? So I think if it's not clear why you want to have a patent, then maybe you should consider not to do it, right?
But maybe I can add on that. If you have a product and you cannot analyze it on the market, whether or not it infringes your patent application, so sometimes we say to you, okay, just keep it secret. Don't try to file a patent application, because after 18 months it will become public. And if you cannot look for infringers on the market, why should you apply for a patent? So that's also a very good reason not to file a patent application, just to keep it as a secret.
But what I do think, Rudy, is that what is important for every company or for every R&D or for every people that's working with innovations is that you have a conscious decision whether or not to patent. So if you have a new idea or a new innovation, then make a conscious decision, okay, I would like to patent it or not. And if you don't patent it, then maybe consider publishing it so that nobody else can patent it. But at least make some sort of conscious decision, okay, patent or not to patent, because we also often encounter people that come to us and say, okay, I had an idea and now it's really popular all over the world, but I had it a year ago and now I want to patent it. Yeah, but now you're too late. So make the decision once you make the innovation or the new idea, and then make a conscious decision and then stick to it, basically.
Yeah. Coming to the end of our talk today, if you look at the next, say, 10 years or so, what do you think is going to be kind of the most important developments that you see coming? What's going to change that's going to affect all of us in terms of patenting and thinking about protection?
It's of course AI. If you look at AI, especially from the government side of view, search reports are prepared by people, and we always are surprised that the search report produced by a Japanese patent attorney is different from the search report prepared by a USPTO examiner or an EPO examiner. That's frustrating for us as patent attorneys because we advise our clients and we have to argue, okay, the search report from GPO is different from the one in the EPO. When AI comes into that area, you will see that the quality of the search report will increase huge because they all have the same system. There's no distinguishing between Korean language or Chinese language or Japanese language. The AI tool can search nearly everything. So the quality of the search reports will increase dramatically. And that will have an influence on all the examiners all around the world because some of them, they will be redundant.
Am I allowed to add something? So I think also which perspective you would answer that question. So if I look from a technical perspective, I think in the next 10 years, I'm working on 6G already. I'm working on AI kinds of applications, quantum computing, all these kinds of new technical domains that really pop up everywhere. And those are becoming more and more popular nowadays. If you look from a legal perspective, I still have some hope that there will be some sort of system that covers multiple legislations, multiple countries. So we have some incentives going on in Europe for the Unified Patent Court and the unitary effect of patents, European patents. And of course, maybe 10 years is not the time period which is sufficient, but maybe in a bit years more, there will be some sort of worldwide system. That's at least what I hope.
And finishing the talk, is there perhaps any advice or anything you want to share with our students here?
I would say
Become a
just
patent attorney.
come into contact. I mean, I basically searched for jobs like a year ago. So yeah, and I encountered this wonderful company. So I would really encourage you to do the same, because yeah, it's maybe not what you thought about before studying, but maybe now it's maybe your thing. So yeah.
I think maybe to add this question to Tim. So what many people think, students think, okay, I have a master's degree and I want to do something with my technical knowledge. I have a master's degree, I want to work with a big multinational company, for example, in the neighborhood of Eindhoven. And many people think that becoming a patent attorney, you lose everything you learned. And then maybe my question to Tim, you've been here for 6 months, right? Do you need your master's degree to understand the technology?
Yeah, you really need your technical background, because otherwise you will be hopelessly lost.
And you have to understand that the job of a patent attorney is very dynamic.
Yeah.
Next week, my agenda is fully blank, but again, this morning I received several calls from clients. Do you have time to discuss blah, blah, blah. So every week is a new week for us. And there is no week which is the same as the past week. We have a very nice job. It's also well paid, which is very important. But you are able to be in your comfort zone. And sometimes you go out of your comfort zone, but there is a lot of nice work. You have contact with clients. It's really a really nice job. I'm doing this for more than 30 years and I learn every day. Every day is a new day for me. Okay. Never boring, not at all.
Great to hear. Well, thanks so much for joining us today, for recording this video, and
perfect.
We'll be talking to you soon.
Thank you.
Thank you so much. Bye-bye.